Welcome. This is the Contract Negotiation Workshop, co-hosted by the American Composers Forum, Springboard for the Arts, and Slam Academy. I'm Vanessa Rose. I'm the President and CEO of American Composers Forum. And this series that we've been doing with our partners was started in response to COVID-19, and it's our joint effort to give information, resources, toolboxes for artists at this time. If you click on archived, the creative development webinars, you will see some past webinars that might also be helpful to you. At this time, it's my pleasure to introduce Andy Sturdivant, who is the Artist Resources Director for Springboard for the Arts, and he will introduce our special guest today.
Thank you very much, Vanessa. Hi, I'm Andy. I'm, like Vanessa said, Artist Resources Director for Springboard for the Arts, and I'm also the coordinator for the Minnesota Lawyers for the Arts program. So the two attorneys joining us today have been involved with the Minnesota Lawyers for the Arts program for a long time. They're both very knowledgeable and very enjoyable people to talk to, so I would be happy to introduce them right now. Since 1988, Terrence W. Moore has been navigating the high-stakes business situations, including film, radio, and concert deals. He's the author of the book Big Force Negotiations. He's been recognized as Lawyer of the Year in Minnesota, as Super Lawyer by the Minnesota Law Journal, and has received the President's Award from the Minnesota State Bar Association. He practices with Hellmuth Johnson in Minneapolis, and you can hear his show, More Around the World, on Sunday mornings on KQRS Radio. And Alexandria Mueller is an award-winning composer, musician, and entertainment attorney. She's the chair of the Sports, Art, and Entertainment Law section of the Minnesota State Bar Association and author of a chapter on music transactions in the Intellectual Property Desk Book for Business Lawyers, published by the American Bar Association. Alex's practice is concentrated on copyright, trademark, and entertainment law. She works with businesses of all sizes in a variety of industries, including filmmakers, event vendors, musicians, and performing ensembles, composers, artists, authors, and game and software developers to manage their rights and maximize their market potential. So with that, I'm going to turn it over now to Alex and Terry. Thanks.
Thanks, Andy.
Thanks, Andy. Hi, everybody.
So just to get started, we wanted to cover a little bit about contract basics. There were a few questions that came in from people who registered. So this will be kind of a theme as we go through some of the problem solving around COVID-19 issues. But just remember that a contract is essentially a bargain for exchange. You and the other party agree to what you have to do and what you want them to do. They're very flexible and they're determined by what you put in the agreement. So long as you're not making an agreement for anything that's illegal, you can really have a lot of leeway to do what you want. What is in the written agreement is ultimately what's binding. Typically, external evidence is not part of the agreement, won't be considered. So you want to have something in writing whenever possible. Not having it in writing creates an evidence question of who said what and whether an agreement actually ever existed.
You can agree to anything you want to agree to, and whatever you agree to is what's in the writing when there is a writing, unless it's ambiguous, which it always is. So one of the big lessons I've learned over the years is get it in writing, understand what it says, but trust your business partner, or don't go into a contract with someone you don't trust because the contract can't keep them from cheating you.
Right. We had a couple of questions about what terms are included in a typical composer contract. In short, who, what, when / where, how much, and rights. So the who, make sure that person signing the contract has the organizational authority to do so. If you're contracting with a school or another nonprofit type of organization, make sure that your contact at the organization might not be the person that needs to be the one signing that contract. And then similarly, if you own your own publishing entity as a composer, you might consider having the entity be the signatory rather than you as a person, even though you are the one that's going to be performing all the work, just to keep your business structure separate from your personal business. The what, in a composer commission agreement, whether that's for an opera, for a concert band piece, for a film score, any of those things, usually there's some parameters for what the instrumentation is going to be, what the length of the piece is. There might be theme or subject matter or in a particular occasion that the work is intended for, like an anniversary celebration. There might be expectations about the skill level for the performers, like if you're writing for high school band, for example. When is the next one? Make sure that you know of any firm deadlines. If it's being written for an event, you need to have enough time to do it, depending on how fast you work. An event happening next month might not give you enough time. You want to have some extra cushion usually to finish up a work. Discuss with the client whether there's any milestones or check-ins along the way. Like, do they want to hear a theme as you're working? Usually on film scores, the directors want to hear something as it's in progress. On concert music commissions, that's not as typical, but it could happen. Is the premiere date set? Is the location set? Are you expected as the composer to attend any of the rehearsals? Or are you expected to attend the performance? Which leads into how much. You have your composing fee, obviously, but you want to also account for costs. Those could be expenses like printing, shipping scores. If you're expected to attend the premiere, are you getting a travel stipend? Are they expecting that you attend a rehearsal and a performance and you're potentially staying overnight? All of those types of things should be something that your contract actually contemplates, and it's totally fine to roll all of that into your costs. The next section is the rights. This is the most important one. In copyright, it's actually a plural. There's 6 rights in the Copyright Act. You have the right to copy, distribute the copies, make derivative works, perform the work, display the work, perform audio recordings on the internet. Now in the music industry, there's a whole bunch of other names for a lot of these rights that overlap. You'll hear things like grand rights, performance right, mechanical rights, master use, synchronization right, print right, referring to sheet music. And so they don't line up exactly one-to-one with what's listed in the Copyright Act, but you want to make sure that your contracts consider all of these rights. For music, also keep in mind there's 2 copyrighted works involved. There's the underlying composition, what would be on the sheet music, and then there's any sound recording. And sometimes those are not owned by the same person. So for instance, if I wrote the music, but someone else records it, they have rights in that recording, and I have rights in the underlying composition. So if somebody for a film wants to use that other artist's recording, they have to get permission from them and from me, because I own the sheet music, you know, the underlying composition. And I can't give the rights to the recording because I don't own that one.
Alex, does anybody still write on sheet music anymore?
Yeah, sheet music is a whole whopping like 12 cents every time you sell one. So a lot of composers have moved to self-publishing. There's still a lot of sheet music published for high school bands, grade school orchestra, that type of thing. Hal Leonard and J.W. Pepper are 2 of the biggest markets for that. Also Alfred Music. But like for records, a lot of times there's not sheet music at all. They record in the session and then nothing's ever written down except maybe a few scratches for chords, but you still have rights in the composition, whether you ever wrote it down or not. So what we see in composer agreements, oftentimes people giving up too much rights, too many of the rights. For instance, I've seen commissions for a high school band piece giving the right to make the first commercial recording, which doesn't make sense because they're never going to do that. So as the composer, when you create the work, you have the right to make the first commercial recording before what we have statutory rights, mechanical recording comes into place after that first recording exists. So if you give away the right to make the first commercial recording to a high school who's never going to do it, no one else can ever make a recording unless you make one. So that can be a problem. Not having the right type of rights is another issue. So this has happened where a composer is commissioned by, this is a true story, more than once actually this has happened. Composer is commissioned by like a community orchestra to write a piece, and then later the community orchestra had the idea that wouldn't this be nice, it sort of sounds like ballet music, wouldn't it be nice if we asked the local dance troupe to choreograph a ballet and perform it to your piece? The composer's like, okay, that sounds cool. The problem with that is that ballet is grand rights as opposed to performing rights. So this composer hadn't contemplated that in their contract, And because the PROs, ASCAP, BMI, CSAC don't license grand rights, this composer couldn't get any royalties on any of these concerts that were performed by this orchestra, because now they fell under grand rights and not performing rights. So don't make that mistake. Another really important thing regarding rights is a concept called work for hire or work made for hire. You'll see both, they are the same thing. This is a device in the Copyright Act. It's literally printed in the statute. What it does is transfer the ownership away from the creator of the work to the commissioning party, so long as there's a signed writing that says the work is a work for hire. So don't use this term at all in your contract if that's not what you intend. I've even seen people that think this is the title of a type of contract. So they'll call it, instead of like composer agreement, they'll call it composer work for hire. And then it tries to say later, like composer retains all the rights. Don't do that. Don't use these words at all unless you actually intend to give the commissioning party all of the copyrights. What I tend to recommend, if for some reason you want to split the copyrights with the commissioning party, it's better to use an assignment, which will give them some portion of it. Like you can give them half, or you can give them just the rights to collect the royalties. Like for example, sometimes parties only care about the sync right. So they're like, yeah, you can go make recordings and release it on Spotify and whatever, but we want the right to the premiere, and we want the right to license any sync agreements. And so you can give them just that portion and not all of the copyrights.
And just to underline what Alex just said with regard to work for hire, from the other side, from the side of the person who's hiring you to compose something, if I get a work for hire agreement, my advice to the client is I own everything. Composer owns nothing. They're paying you $100 to paint your fence. That's what they're doing. And if that's the deal you want, that's great. But anytime you see work for hire, you should think this is a one-time job and a one-time check.
Yep. And there are some situations where it's common to use the work for hire. Like if you write for Disney, like you get the opportunity to score a film for Disney, you're going to sign a work for hire. Mm-hmm. That's just how those work. And the main risk for work for hire is because you're parting with all of the copyrights, and copyright in the United States is life of the author plus 70 years. You're missing out on potential additional revenue other than what you got paid the one time to make the work. So that's why you don't want to part with your copyrights without a number with, like say, a number with a lot of zeros. That's when work for hire is appropriate. If you're dealing with an unsophisticated party, like someone who's maybe an arts organization that hasn't commissioned music before, be prepared to teach them what's involved, especially when it comes to the rights and when it comes to the timeline. Often they really don't know what's involved. They don't realize it takes 100 hours or whatever it takes you to complete a band score that's 10 minutes long and do all the parts. So make sure that you're the one who knows how this works. You're the one that should be communicating that to your client. It's a really good idea for you to have your own contract template. And it's a really good idea to have this anyway, even if they are a sophisticated party. Just, you don't want to wait for them to come up with terms that are agreeable to you. Just put in front of them what you want and what you expect, and then see if you have a meeting of the minds. Very importantly, don't use a template that you don't understand. I see this all the time. People go on a Facebook group, they're like, does anyone have a template for blah, 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 blah? And I'm like, really? Like, do you ask your friends for prescription drugs? Because that's about what that means. There's a lot of flexibility.
Alex, these are artists. Sometimes they actually do.
Don't do that. There's a lot of flexibility in contracts, even when people throw around words like, oh, this is standard. This is just what's in there. It's standard. So you don't want to be in a situation where your best interests are not served because the template you found doesn't fit what you're trying to do. Other risks with parties who don't know what they're doing. If you have a lawyer, because you're being a serious business person and you have an attorney helping you, if you're using a lawyer and they don't, you want to be careful that your legal fees aren't accumulating because they don't know what they're doing and they won't get a lawyer because your lawyer has to like fix things multiple times or explain it to them. I've had this happen with a couple clients, and I've told the client, I'm like, look, I'm not billing you for this. This is just like, they don't know what they're doing and they're taking up lots of our time. There are a few guides to commissioning music floating around. I know American Composers Forum has a page on this, and Meet the Composer had put one together a number of years ago. I think it's still around, and that's a really good document to look at. You could even give that to your client or adapt it, something like that for your own needs that explains, you know, here's what I charge, here's how long it takes me, here's how the contract looks, and just lay it all out. So that's how contracts typically look. Now, a lot of things are changing because of COVID-19. We have a lot of uncertainty. So Terry, you want to talk about that?
What's COVID-19?
It's a very serious disease.
Yeah.
It's killed 100,000 people in the US.
Yes. And it has really created some, what I used to call law school exercises in the contract world, especially around events, performing artists, weddings. There's a plethora of people out there right now who are trying to keep the money that's been deposited. For example, if you were scheduled to play at a wedding, to keep the money for the venue, for event hosts, weddings, other sponsors, promoters, to try to get deposits back, because now that the event is not happening, the contract can't be performed. So I'm going to talk about a couple of different things. One, who's going to be liable under a contract, but also the concepts of illegality, impossibility, and force majeure. These are all legal terms of art, but they're very important in this time. If you're a performing artist or otherwise want to get paid because an event is booked and going to take place, there are ways to get paid, and there are ways to keep the money that's been deposited, and that's what we're going to talk about today. So, first of all, fundamental contract law. Contracts are generally enforceable against the party that signs it. So Alex mentioned in passing that you might want to have your contract signed if you have an LLC, or if you don't have one, get one. You know, if you're in business, get one, because it protects you personally from any liability for disasters that happen, but also for in a contract situation, it can protect your personal assets if things really go south. So that the party that signs the contract, Joanne Smith Compositions LLC, signs the contract, and then if you're supposed to be paid for something, you get a deposit, and now that event is canceled. What do? Well, what you want to look at in the contract is, first of all, there's a concept, and this sounds very legalese, called force majeure. A long time ago, they called it act of God. And then they called it act of nature. And now they use Latin force majeure because what it is a list of things that could completely undermine the purpose of the contract. And if that happens, we agree at the beginning that we're just going to void the contract, and we'll give you your money back, and we won't expect to play that night.
And Terry, is force majeure one list that exists somewhere that includes all those things, or is it each list specific to an individual contract?
So every contract is going to have an individual list. Now, at the end of that list, it's going to say, or other similar events, which is where lawyers come in to litigate whether that's what you were thinking of or not. But a force majeure event, 100 years ago, never included a strike. But 100 years ago, there was, in the 1920s actually, there were a series of strikes that disrupted manufacturing contracts, and these were violent strikes. If you go back, there were if you've seen Gangs of New York, that wasn't it, but it was like that. Street fighting, it was awful. So anyway, so a strike became something that lawyers will talk about on a significant contract. Is that going to be a force majeure or not? Imagine if you're a National Hockey League sponsor, you're going to put out $5 million, and if there's a player strike, you need that in the contract. Typical force majeure are what you really think of as the acts of a vengeful God: hurricanes, fires, earthquakes, unbelievably bad weather that prevents delivery trucks from even crossing the country, so they can't. So in 2001, what happened? A terrorist attack on the United States. Since then, force majeure clauses almost always include terrorist attacks. Now, going forward, you're going to see the word pandemic, which had appeared a little bit over the last 10 years, but now that's going to be a force majeure clause. But, which leads me to the next piece, because if you have an existing contract now, you were supposed to play somewhere on June 1st, and they can't open the bar where you're supposed to play or the concert hall. You don't have pandemic in your force majeure clause. You may not even have a force majeure clause, unless you get a really good lawyer, but we'll talk about that later. So how is it that we deal with something that clearly undermines the purpose of the contract, right? They're hiring you, and they're paying you $25,000 to play in front of 25,000 people. Or better yet, they're paying you $5,000 to play in front of 350 people while they sell alcohol. They can't open the place. They can't open it because the governor has said you're not permitted to have a gathering of more than 10 people. So does that mean that they have to pay you $2,500 to play for 10 people? Probably not. And that's the concept of impossibility. A contract is void if it's impossible. My own daughter scheduled to get married in April of this year in Palm Springs. In Southern California, they shut down all gatherings of over 10 people, shut down the hotel where the wedding was supposed to be. It was absolutely impossible to perform the contract, but it was also illegal. Second part of void contracts is a contract is void if it's illegal. So in other words, I can't pay you to drive bootleg whiskey across from Canada, an illegal act, we'll call it. If you deliver the whiskey and I refuse to pay you, you don't get to go to court and enforce that contract because it's an illegal act. So apply that to your bar gig. Let's say the bar was not allowed to be open at all. Therefore, it is an illegal act to have that gathering, have that concert. Now, they could put you on stage by yourself, and that dovetails with the impossibility I talked about before, because that's not what the contract was for. An illegal contract is void, an impossible contract is void. If you've got a force majeure list, that will also void the contract. But we really have to talk about, when you're thinking of what you're going to do is get a call. They're going to say, hey, we sent you that $1,000 deposit, and now our contract's void because it's illegal to perform in the bar on the night that you were supposed to perform. Or the wedding's been canceled because the venue can't host it. Therefore, our contract's void. Send me back the $1,000. As the person, when I'm representing people who are in those shoes, I'm telling them to chase down the money, and legally there's a very strong argument. But from the composer side, you also have an argument, or the performing artist side, you also have an argument, which is presumably you have a no refunds under any circumstances clause in your contract. And now you decide whether you want to fight over that $1,000 deposit or that $500 deposit. And I think this is a key point. You have a relationship with this venue, and you have a reputation. People want performing artists who are, of course, super talented and entertaining and draw a crowd, but also that are easy to work with. If you fight over the $200, then what very well might happen is they'll say, yeah, go ahead, keep your $200, and then delete your phone number from their contacts. That's the last thing you want to have happen. Because, by the way, venue people know each other and they talk to each other. They'll say, yeah, so-and-so insisted on keeping the $200. We'll see how she feels about that next year when we don't book her. So then question is, does that mean you have to give back the $200? No, there's a win-win way to handle it. If somebody's asking you for the deposit back, you don't want to fight it unless you really want to fight it, but you're risking your reputation. But you don't want to give it back because, which of us has too much money in the bank at this point, especially at this point. So, and what do you really want to have happen? You want to get as many bookings as possible for as long as possible out as you can pre-book yourself. If you're the Rolling Stones, you're booked for the next 17 years, even though they'll be how old, I don't know. But, so here's what you do. Someone calls you and asks for a deposit. Say, yeah, that's a bummer. I really love playing your event. I had a great time at it last year. I tell you what, let's do. Let's just transfer the deposit from this year to next year. I'll commit to next year's event right now, and we'll consider that the deposit. I'll even do it at the same price. And that will allow you to, A, be polite and nice and kind and have a good relationship with the booker. B, keep the $200 for now. And C, get a gig for next year already. And at this stage, if you're fully booked for the next 6 months, if you could transfer that all into the summer and fall of 2021, that's a pretty good place to be under the uncertain times we're in now. Wouldn't you agree, Alex?
Yep. I have a string quartet that plays weddings, and that's exactly what we've been doing. We're just moving with couples to their new date that are next year. And I just want to highlight too, you can make changes to a contract after you've signed it. You just sign a new piece of paper that says, we're making this change, and then you both signed it, and now that's part of the contract.
Yeah, so that's called an amendment. And it could be actually as simple as an email saying, hey, this will confirm our agreement that we're changing, we're amending, use the whatever word you want, but we're changing the contract for June 6, 2020. It'll now apply to your event on June 8th, 2021. And that's enough. That with a lot of follow-up as the months go by, because you always want to do that anyway, but that you'll have a contract you have a booking for next year. It really is a win-win for everybody, even for the booker who says, yeah, this is great. I've got one more act booked for next year, right?
Yep.
So the last thing I want to talk about, and then we'll open this up for questions, is what do we want to put into new contracts? What should contracts look like now? Raise your hand if you've ever thought of if you ever had an event canceled by a pandemic before 2020. Raise your hand. Now I can't see anybody out there, but I'm assuming nobody's raising their hand. So, but now everybody's had events canceled with pandemics, and I think that event venues are going to write I think it might even be outside of the force majeure clause. I've seen drafts of clauses that say, if there's a pandemic, here's what will happen. And this is why you want to have your own contract to send out, because if the booker sends you their contract and it says, in case of pandemic, you will return the money within 30 days of written request, and then you're bound to that, right? On the other hand, if your contract says, in the event of pandemic, then the deposit this contract shall not be void, but the deposit will be transferred to a future booking. See the difference there? How different is that phone call from the booker who says, I'm canceling, send the money back, or I'm canceling, our contract says you have to apply the deposit to booking for a later booking. And again, everybody's happy to have another booking and to keep the $200. So, that adds?
Yeah, there's still a lot of uncertainty about contracts that are happening or supposed to have happened in the next 6 months here. And some presenters I know are looking at alternative formats, like having drive-in concerts or doing streaming. We had one question from a registrant that was asking about opera specifically, and this would be grand rights again. Streaming is a problem for grand rights because those things are negotiated directly with the publisher, the rights holder, even if you're doing it live in a theater. Remember the example with the composer who couldn't get performance royalties from ASCAP. It's because they don't cover grand rights. You have to go right to the publisher. Typically in those agreements, you're not allowed to stream, you're not allowed to record video or give out DVDs or anything like that. So if you're going to shift your concert or your opera to online, we'll stick with opera for now. If you're going to shift to an online streamed format, you're going to have to redo portions of that contract because you don't have the rights to do that. If you're licensing the work yourself, you're self-published, you can absolutely do this. If your work is published through someone else and your publisher is not on top of this, get on the phone and tell them to get on top of this. I would say avoid platforms like Facebook and YouTube that automatically make an archived video of the stream, because you're not going to have the rights to make that, even if you get the rights to stream live. I know a lot of organizations are trying to use platforms that allow a paywall, so they'll sell, like a ticket through Eventbrite or Ticketmaster, and then what it sends them is a Zoom link and a password, and so you are limiting the size of the audience just like you would in an actual theater. Another idea I've seen is selling season subscription tickets this way, but I would say the caveat there is you're not going to be able to get the same high prices that you could for a theater pass to the Guthrie, for instance, because your experience is different. Like people that are buying season sports passes and season opera tickets are expecting to go to the theater, have that experience, have that social interaction. When you switch it to an online medium, you're competing with services like Netflix, and Netflix offers, it's like $12 a month, and they have thousands of hours of content in there. So I would just say, be mindful of your price point when you're offering the work in a different format.
There were a couple of questions that just came in too that
Okay, great.
we can get to right now. So there was a question about language here, and in terms of including language like, quote, in case of shutdown by civic authorities. You know, is it useful to get that granular with the situations that you're describing?
I think you can. You might save, Terry can weigh in on this, you might save, you know, a litigation question if you make it that specific, like if there's a stay-at-home order, this is what we're doing. But if you say, if there's a pandemic and then you disagree whether there's a pandemic going on, now there's a question which leaves potential for litigation. Terry, what are your thoughts?
My thought is this comes to what I call the green M&M standard. I wish I could remember the name right now, but there was a major artist, rock and roll star, who insisted in his rider that he have a bowl of M&Ms all green in his dressing room. If you can request that kind of thing in your rider, then you can request just about anything. But the reality is most of us don't meet that standard. So what you want to have in your standard contract is something, you want to have it short, sweet, and powerful. So when we talk about granular level, like if case of shutdown by civic authorities, I think that it's better to be just maybe a level above that. In case of shutdown caused by law, or you can use governmental authority, which are not exactly the same thing. This is what shall happen. What's most important in that clause is the second half. What happens if it's shut down? Now, contrary to what I just said, I think pandemic / COVID-19, you have a contract that's going to be enforced in the next 12 months. You're going to perform in the next 12 months, right now. That I would have an agreement as to what are we going to do if COVID-19 has a second wave or a third wave. If we're shut down by COVID-19, here's our plan. Now, it should be in your standard contract because you want to be able to just send them the contract and have them sign it. You don't want to hire a lawyer to negotiate I'm sorry, did I just say that out loud? You don't want to hire a lawyer to negotiate a $3,500 gig deal on the fine points of what's going to happen on COVID-19. You want to have that in your standard contract, and I think you do want to have a provision that says, and my recommendation, general recommendation, everything is specific, but my general recommendation is it ought to say, if COVID-19 shuts this gig down, we're going to transfer the deposit to the next gig and rebook it.
Mm-hmm.
Great. And there is another question here. Do you have any comments on what artist managers should include in contracts regarding COVID-19 protocols at venues? For example, can we require in contracts that audience members must wear masks?
You can make, just in general, you can make requirements for patrons part of their ticket purchase. So like when you go to a baseball game, you may or may not be aware you're signing a whole big long waiver about if you get hit by a baseball. So you can definitely require certain behaviors of patrons as part of your contract with them to give them a ticket. As far as what those parameters should be, I would defer to the state guidelines. There's a whole bunch of information that just came out that talks about COVID-19 preparedness plans and what the expectations are.
So I can add to that very specifically about wearing masks. I think you can have a requirement easier to accept. I'm pragmatic. Easier to accept for the venue is that they have to follow state or CDC or whatever guidelines are out there with respect to public safety issues. So,
yeah. There was a question about how, and this, could be a whole another discussion. How is COVID-19 specifically affecting composers? The main issues are events are not happening that would generate royalties for us. I've had, for instance, I work in film media. A lot of productions weren't able to shoot. Some of them got close and couldn't finish. And that eventually trickled down to the composers who are in post-production. So like, this movie's not getting made. We don't need a score in the foreseeable future. You're not getting paid. And it's like, okay. Every time I opened my email for a while, it was like, this is not happening. This one's not happening. You're not getting paid for this. If you agree to let, say you got commissioned for a piece that was supposed to premiere this year and they decide they're going to stream it instead of having it at their hall, you have all of those concerns about what platform they're using. Are they using a paywall? You basically have to think like you're licensing grand rights now, because these platforms don't pay performance royalties the same way that a concert hall would. So if you have someone that's doing a show on Facebook, you're not, as a composer, you're not going to get paid for that. It's how it works right now. They don't have a music licensing structure sorted out that allows you to get paid or allows you to track it. You won't get paid royalties. It's like normally a concert royalty is really good. Even if you have a venue, you have like maybe 50 people there, it seats 100 or 250 people, you're easily going to get $50 for that performance. If you have something played at a college on a recital, easily $50 for that performance. If they do it on Facebook, nothing. You're going to get nothing. So go back and do those contracts in a way that makes sense for everybody involved. Okay, Andy, other questions?
Okay, and yeah, there is. So let's see here. Regarding a contract amendment to apply to a future date, if it is not possible for the venue or presenter to identify a date yet, how can the artist ensure that a general future date in the contract is followed through on in a reasonable time period?
Yeah, that's kind of up to everyone involved. A lot of times when you're putting like a music festival together, they don't put specific dates in it quite yet. They'll be looking a year or two out with what's called a letter of intent. They're like, hey, we want you to play this festival. Are you interested if we, go ahead with this? And you're just basically saying, yes, I'm interested. And this is kind of bare bones what we talked about, but they're not making you commit to specific days yet. And so if you have a contract in that event, like the state fair, for instance, got canceled, so they're going to be looking at next year, but they may not know if you were supposed to perform on Thursday this year that you're going to be on Thursday next year quite yet. But you can be like, it's happening in that 2 weeks. So you can be granular again or broadly, but if they try and reschedule you and commit to a date 5 years out, maybe you don't want to do that. It's totally up to you.
And you can put an expiration on it, at a, let's just say it's a bar gig, right? So it's not a event like the state fair. You can say an event sometime before year end 2021. So hopefully, you follow up, you'll get the booking, but if nothing else, you'll get to keep the deposit a year and a half from now when everybody's forgotten about it.
Thank you. I'm going to take over from Andy now. We have a few more questions here. One is back to negotiating contracts for the future. Would you recommend having a pandemic clause that might cover possible scenarios from pandemic-related travel disruptions, local outbreaks, or infected ensemble members, for example? Would there be a difference between domestic and international events? And do you envision that there will be some sort of generally agreed COVID-19 contract clause upon in the future?
I don't know about a general clause. What I've been seeing happening with international issues, so the contract is subject to where the work takes place. So if it requires you to travel somewhere to perform it, you could absolutely run into international issues. Like we had a film crew that was supposed to travel out of the country that could not because of a travel ban preventing them from landing where they were supposed to get to. Terry, you want to comment on that?
Yeah, with regard to standard clauses, well, actually, first I'll revisit what Alex said. What I've seen happening now is, for example, we've been able to void contracts as impossible because wedding contract where people were traveling from India and from Europe, where those borders are closed right now. The travel is illegal. It's a little sticky because how important is it to have your cousin Fred at your wedding? On the other hand, if it's your mother, maybe that's a little different thing. With regard to standard clauses, there are two general clauses. First of all, I think you ought to have any gig that you're doing in the next 12 months and maybe through the end of 2021, there ought to be a COVID-19/pandemic specific clause in it. If this happens, here's what we're going to do. Because nobody knows what's going to happen. But there's two standard clauses that will emerge. One, that the venue, the paying party, will want in the contract is, if we have to cancel, you have to give us our money back, short time frame, and that's it, done. Okay, that's not what the artist wants. What the artist wants is what I talked about before, which is, I'll go through it again. It should say, if it's shut down by COVID-19 or a pandemic, then we're keeping the deposit for now. We're going to allow you to transfer it to a future booking to take place. If it's an event, then it's at the 2021 State Fair. If it's just a regular gig or a tour or something, then you have on a date within the next 12 months or by year end 2021. And those clauses clash, and it kind of gets us back to the green M&Ms, right? How big a deal are you? What can you insist on? But if, as most of us fall within the standard contract, which is, I put in air quotes because it's not really standard. If you have a standard contract and it's got your language in it and you present it to them, they will often not want to fight about it. They'll sign it. You're one of many people that they're booking. Boom, done. And now, if things go south, you've got your language in it.
I have a tandem to that too, which is the legal protection for health considerations, both protecting the performers from any legal action from concert attendees or organizers, or similarly, if the performers end up having health issues as a result of the event. Are there considerations in the contract for those?
You could. Personally, if I was hiring performers, I would rather that they were honest and told me they were sick, and then I would literally pay them anyway to not come, than to make all my other players sick.
Yeah, and there's the concept of assumption of risk, which is another legal concept where if you jump off a building on a bungee cord, you've assumed the risk. Now it's in their waiver, it's in their standard contract. But with COVID-19, I think a player who comes when they're well probably assumes the risk, but maybe it ought to be dealt with in the contract. But what I think is, unless I'm a big deal or very likely to get sick, I don't think I want to ask for that. You know, if I get sick at your venue, I'm going to sue you. I think they'll just sign somebody else. On the other hand, I don't think it's unreasonable to ask for the protocols we talked about.
Mm-hmm. And you can require those, you know, downstream too. If I say that I am recording a film score, so I'm hiring the players for the session, I can make that part of the contract I have with the players that everyone has to have PPE, they have to provide it themselves. And this is just one of the expectations for coming to this space and how to act on it.
Thank you. So we just have, it's 11:53, just putting that out there. We have a few more questions, and if you have questions you want to ask, please put in the chat box. We'll try to get to everybody. I have some more general questions here. For contracts directly with performers that don't involve transactions, I provide music, they provide recording. Is it still better to sign with my LLC as a company rather than myself as a person?
Alex, I'll take it. Generally speaking, I think it's better to sign with your LLC from a lawyer's perspective. You know, the Beatles had Apple Music, by the way, whole different Apple company. Everybody remembered the Beatles and McCartney and Lennon. Nobody said, oh, wow, Apple wrote those songs. So, I mean, I don't think it affects the recognizability of who wrote the work. It's just a legal term that nobody ever sees.
Thank you. Another question is DCI streaming, flow, marching, grand rights, and then would DCI DVD audio sales be considered grand rights?
Grand rights has to do with whether there's a theatrical overarching thing to the performance. DVD is distributing on a physical medium. If it involves video, you need a sync license for that. And so that's not grand rights. Grand rights is another species of performing rights essentially, but they wanted to separate them a long time ago because grand rights are perceived to be much more lucrative, whereas performance rights in like you're playing on a recital, you're playing on a concert, you're playing at karaoke, that type of thing. Those are like any song is just as good as any other song, and it's the size of the hall that determines it. I don't actually know the answer to that off the top of my head. I think that, so we're talking about drum corps, that may apply to all marching band stuff that has choreography, and I don't actually know off the top of my head if that implicates grand rights or not. But if you're streaming it, you run into the issues of you're not going to be generating royalties for the composers. And if you're doing DVDs or even downloadable things, same issue, you need sync rights to do those. Those aren't covered by performing rights at all.
Thank you. I don't have any other questions in the chat box. Do you want to offer any kind of last thoughts or resources for folks to look at?
Yep. Do we have the link from Andy? I know he had to take off. So in Minnesota, we have the Minnesota Volunteer Lawyer for the Arts. You can get a free 30-minute consult with folks like Terry or I. There's a link on Springboard for the Arts page to the national version of that if you're not located in Minnesota.
And I would add to that, don't hesitate to call. Some people think that getting a free half hour with a lawyer is imposing on us. We wouldn't do it if we didn't enjoy doing it. And if you've got a real problem, you can hire us. But most of the questions that we handle are things we've seen before, and we can help you, and we're happy to do it. I'd rather talk to you guys than normal people.
I want to thank you both so much for your time today. So incredibly helpful with such a broad subject and so many intricate details to be mindful of. So I'm getting a lot of thanks in the chat box, just so you know. So yeah, really appreciate it. And for those of you that maybe have questions later, please feel free to reach out to us or Springboard for the Arts, and we'll be very happy to continue the conversation.
Well, thanks for having us.
Thank
Thank
you
you
so
so
much.
much. Thank you.
Bye.